Makwa baba TV SYZ so ene adwada no pay abusuafo bɛkae a bosome miensan mu da aduonu nkron ana mmarahyɛ bedwafo agye mmra na da wo manim a yato ne din sɛ E-Levy no atu man bɛyɛ mmra na ansa wo bɛgye mmra na tomu no ɛdɔm kuma no twe wo firi mmarahyɛ bedwam ɛma ne ka dɔm kɛseɛ no nko a ana wo gye mmra no tum na no akyi ɛna ɛdɔm kuma no de asɛm no akɔkɔpiem Supreme Court sɛ ɛkwan ɛdɔm kɛseɛ no fa so gye mmra no tum no ɛnyɛ ne kwan so no because Supreme Court aka sɛ ombetime esi gyinaye wo mmarahyɛ bedwam ho bia agye sɛ mu wɔ nipa a ɛyɛ 138 ansa no metime esi gyinaye na time a ɔmo si saa gyinaye no na ɔmo ni saa 138 na ɔmo di si saa gyinaye no nti Supreme Court ɛnhwɛ na ɔntwe saa amra na dɔm kɛse na agye atum no ɛnsan asɛm wɔ court Supreme Court nyanhyɛ da a ɔde bedi asɛm no ɛnso finance minister ɛde ato yɛnim sɛ 1st May ɛyɛ na no kwasiada yi ana ɔde saa amra no ɛbɛyɛ adwuma enti ma mmarahyɛ bedwafo miensa na ɔmde asɛm no kɔ court no ɛyɛ onumonyamfo Harry na Idrisu onumonyamfo Okudjeto Abrakwa ana onumonyamfo Mahama Ayarega ɛkɔ Supreme Court sɛ ɔnsi finance minister ho kwan ma ɔmfa E-Levy mmra no ɛnhyɛ ase nyɛ adwuma ɛfiri sɛ ebia edi asɛm no wie ne sɛ aban difo a ɔmo ntimi nsa mfa sika na ɔmagyegye no ɛmfa amanfo adeɛ ɛmfa ɛnkɔma wɔ mu enti Supreme Court ɛmfa tabo ɛnsi so sɛ yɛ finance minister ɔntimi mfa saa mmra no so ngyi sika bia ɔntel sɛ yɛbɛdi asɛm na wie ɛnso ekopie mu Supreme Court no judge for anso a ɔmo tena asɛm no so nyinaa gye to mu sɛ ɔmo ne mmarahyɛ bedwafo no miensa no ɔmo de asɛm no kɔ court no ɛnya adwene ɛfiri sɛ yɛama ho kwan ama yɛangyegye sika na Ghana man ana ɛbɛsɔfa enti no yɛma ho kwan na finance minister ɛnyegye sika no na sɛ ba ne sɛ yɛdi asɛm no wie na sɛ finance minister anaasɛ aban difo a ɛneɛ obi a agye ne sika biara no ayɛde obi a sika ayɛden ama no afei nso GRA ɛnhwɛ sɛ ɔbɛtoto ne ntotoyɛ yie sɛ yɛ a bi a yɛate ne sika biara na ba ne sɛ yɛkyerɛ saa de ne sika ma no onipa kɔ nsa aka ne sika no aban lawyer panyin a ɔna ɔto abanfo onumonyamfo Godfred Odame ɛnso ɛkyerɛkyerɛ mu sɛ ade a Supreme Court aka no n'ani agye paa firi sɛ de Supreme Court agyagyefoɔ nso no nyinaa agye ato mu sɛ ɔmabɔ asɛm agu no ofi sɛ ne kwan so ano no.
I'm happy that the observations that we made about the application have been affirmed by the court. It's very important to note that the court made the finding that really nothing regular had been demonstrated by the applicant. That insofar as Parliament or proceedings of Parliament in the impression were concerned, everything seemed regular, and we have demonstrated same from the processes that we have tried. And I think that is very remarkable to indicate that yes, the applicant at all times bore the duty. He did not go to court with a bundle of speculations and conjecture. I mean, as the court stated in its ruling in reference to one of the claims by the applicant. Yes, we go to court on the basis of firm evidence. The record of Parliament the day in question, 29th March, showed that at least 266 members of Parliament were present when the question was put for the approval of the E-Levy bill, and the motion was agreed to. That's what the record shows. There was no indication that there was a division or a head count, and for that matter, only 136 people as was alleged by the minority who were present in Parliament. And we saw that clearly, and we all saw what happened. The applicants were unable to demonstrate any form of irregularity in the proceedings. I'm very happy with that. Clearly, that was the motive for the application. Then they failed miserably, for the entire application was dismissed. Yes, the court made the order that GRA should keep records of whatever they collected. And that's exactly what GRA does all the time. GRA, there's no revenue collection agency in the world who does not keep records. So really, the requirement for GRA to keep records is borne out by their statutory obligation. That is what they do. And that's what they so if there was anything that the minority got today was an affirmation of what GRA does, that they should keep records. That is all. Apart from that, the entire application was dismissed, and there's nothing inhibiting GRA from collecting all monies as a result of the E-Levy Act. There's also nothing preventing the government of Ghana from utilizing the revenue for the development of the country, or for utilizing it for the execution of various projects that the government has set out to do. And that's what we're happy by. We believe the people of Ghana will eventually receive the fruits of monies that are collected from this E-Levy Act, and to be applied for governmental purposes. So what happened in court today was an embarrassing spectacle. The lawyer clearly was not able to demonstrate any form of irregularity with proceedings in Parliament. The court has him. So is there any record that indicates that X number of MPs worked out at a certain stage? Is there any record that shows that a head count of all the MPs in Parliament was taken? That was not that. He said, absolutely said no. There was no evidence indicating whether that was a head count of the number of MPs present in Parliament who voted to support the bill. There's also nothing provided by the lawyer that indicated that there was a workout by X number of people in Parliament. So I think we should ignore all that propaganda. In court, we adduce evidence of matters that we can prove, and we apply the law to a resolution of the issues in question. And clearly, today, the proceedings were quite obvious that there was no form of irregularity whatsoever in the proceedings of the day 29th March 2022. In the case, as I indicated, that if indeed, assuming without admitting that it was only or the entire minority worked out of Parliament, the proper quorum for decision making now is, as I stated, 137 and not 138, because indeed at that time the Arsenal MP had had his election cancelled. The Arsenal MP had had his appeal struck out. There was nothing preventing the enforcement to be done to the High Court, and therefore he stayed away from proceedings on the day in question. So really, today he cannot go to Parliament and say he's going to partake in proceedings in Parliament. So the quorum for Parliament now is not 138, as has been wrongly bandied about by the minority. It is currently 137, and that's what we're working by. And the records will show that at that time, apart from Honorable Sarah Adrasa, all other members of Parliament of the minority were present. That's the record of Parliament. It's not my making. It is the record of Parliament that was tendered by the Africans, Honorable Haruna Idrisu and the others.
Opanyin oda dom kumana no onimonyamfo Haruna Idrisu enso ka se ewom se Supreme Court anu ma anya adwene de but o gidie se the Supreme Court aka se GRA digiska na omo hwe so yi koba ne se omo debima yatimi de obi asika ama no e ya asempapa na mmom ogba aban kokose ma onhwe se yenye ndi ase no wie no onfa nkoye nsi achiba ankonkonko gibusia e ba ne sa daachi e be ha oman no.
For us in the minority, until the substantive matter is determined conclusively, we remain determined that even on the balance of weighing monetary considerations against the weight of a constitutional breach, the emphasis should be on what harm we are doing to the 1992 Constitution and the three co-equal organs of state. So in the determination of whether some irreparable damage or hardship will be caused, our hardship as we understand it is the disrespect to the Constitution by the action of passage into law of an Act 1075, with numbers below the minimum constitutional threshold of 138 members of Parliament. Can you imagine? I heard the Attorney General laboriously arguing that it was a voice vote. So Ebenezer Kum voted with his voice from an ambulance, or he voted with his voice from a clinic to add to the voice vote, and he is insisting that 266 members of Parliament participated in the decision and participated in the motion. 266 members of Parliament, after the minority of 136 walked out. Certainly, these are matters that the Ghanaian public can judge better. But what is refreshing and heartwarming today is the second part of the ruling, which gives directives to the Ghana Revenue Authority to preserve and keep the money. At least some people will not be in a rush to collateralize it until the substantive matter is determined. For us, we raise this matter because it's of public interest significance, it's of constitutional significance, and we think that we will pursue it to its logical conclusion. So we are very happy with the performance of our lawyers. We only pray that Ghana is not going to have two sets of laws. One that serves and protects the elected elite of a ruling government, and ones that serve the political minority of an opposition. Judicial notice of our walkout They walked out. They walked out when the budget was rejected. You know the numbers. It was 274. We're not told that quorum for decision was 274, as we are being told somewhere in someone's argument, at least not the court, that 266 passed the motion. What you people should note is that in parliamentary practice, the fact that you took a motion through second reading did not mean that at consideration and third reading, you didn't require minimum numbers. We still uphold the principle. At least, Jesse Question was marked absent from the record that we have. God bless.
Say E-Levy sense me ya man panyin dada John Dramani Mahama so na no atum say NDC aban ba power 2025 a ombeyi saa emra na eden afiri honom. No man panyin dada John Dramani Mahama de saa se kotu dwa wa abra na ne dwumadi a watu din say Ghana yidran kwantana so anase yapem yehu se yanku yanum anase yanku yachi.
We in the NDC do not oppose taxation as a principle. We will not be pretentious and couch fanciful slogans to condemn the principle of taxation like the MPP did in the past. We are, however, implacably opposed to distortionary and burdensome taxes like the E-Levy that only force Ghanaians to endure more suffering. A new National Democratic Congress government, God willing, and with the votes of the sovereign people of Ghana in 2025, will repeal the E-Levy Act.
I was for me, more any share at the share, Musum for therefore, Kwesi Beche, and I'm the Jumedi Ebabe Song. Yami Aduma Dasene, Yabesan Esia.